This is part 2 of the December episode of The Real Crimes of Kurri. In the first part, I discussed the traffic type cases. In this part, I will talk about the 3 last cases that involved an assault, drugs, and a Commonwealth offence. The assault case was similar to the previous assault cases I discussed from November. That is, the defendant was charged using evidence from their own admissions they made to police. The complainant did not give evidence. The case involves an assault to a child who was a teenager. The case is dealt with in an open court. Care is taken not to identify the child, including the name of the school, etc. The defendant is the parent of the child, whose name is said out loud. This is one of the reasons why I don't say the person's name. I risk not following the court rules if I give out any information that might identify the child. I'm going to go as far as not even to say the gender of the parent. So even if you hear something said out loud in open court, it doesn't mean you're allowed to repeat it outside of court. So the story goes, the child goes to school and tells their friends their parent slapped them. The friends tell a teacher. Teachers have a duty to report allegations of this type. It's reported and police become involved. Police talk to the child, who declines to make a statement. Police go on and talk to the parent, who admits they slapped the child. Police use the defendant's own admission to charge them with assault. There are circumstances touched on during the sentencing, which I'm not going to repeat. I just want to say every case may have a couple of sides to the story or complex sort of circumstances. What I'm saying is most cases are not simply black and white. In my opinion, the magistrate took the time to explore the circumstances, considered a few factors and sentenced according to this particular person. We listening in the gallery are told specific deterrence was a significant factor in this sentencing, meaning the sentence was given particularly to deter this person. It's not meant to be directed at deterring the rest of us. Therefore, I'm not going to say what the sentence was. There was one person who needed to hear what the sentence was, which was the defendant, and they were sitting in the dock area when the magistrate delivered the sentence to them. For the rest of us, I think the message out of this case is slapping a child may see you make an appearance at the New South Wales Local Court. The next case involves 17 grams of cannabis. The charge is drug possession, which is an offence under the Drug Misuse and Trafficking Act. As soon as you hear a drugs charge, there's 2 things that I listen for: the type of drug and the amount, because different drugs and different amounts will determine how serious the charge is. This case involves 17 grams of cannabis. I will confess I'm not familiar with what 17 grams of cannabis is. Is it a big or small amount? Meaning I have to look up the law to understand what 17 grams means. According to the law, any amount of cannabis under 30 grams is classified as a small quantity, therefore the lowest offence. For example, being caught with 100 kilograms or more would see the quantity classified as large commercial quantity, and the case wouldn't be heard at Kurri because you would get to experience the district court with that amount of cannabis. The defendant was mature aged and had pled guilty to possessing the drug. By the way, the charge came about after the police stopped the defendant to talk about something related to their car. I'm not sure how the interaction went from the car to the cannabis. Anyways, the magistrate finds the offence proven, however, no conviction was recorded and the defendant was placed on a conditional release order for 2 months. Last case is a Commonwealth offence. Most of the petty crimes in our local courts are offences under our New South Wales state laws. However, Commonwealth laws, also called federal laws, also apply in New South Wales, and some can be dealt with by the local courts. Commonwealth offences are things such as human trafficking, money laundering. So what's this Kurri defendant charged with? They are charged with using carriage service to menace, harass or cause offence. It's section 474.17 of the Criminal Code within the Commonwealth Crimes Act. So not the New South Wales Crimes Act, the Commonwealth Crimes Act. Now, the first question the defendant is asked before they start unpacking this matter is, do they consent to having this matter dealt with in the local court? The magistrate explains that these offences are dealt with by the district court, where the higher penalties are available, unless the defendant and the prosecution consent to the matter to be dealt with in the local court, where the higher penalties are not available. The defendant says yes to the local court. In my opinion, yes to the local court is a good answer. Definitely prefer the local court in Kurri over the district court in Newcastle. The defendant pled guilty to sending a text message. Hold on to your hats, because the magistrate clearly says out loud the exact words that were in this text. which include the not so nice ones, which I'm not going to say. The defendant sent a text to the complainant that said they were going to, quote, beat the F word out of you, C word, end quote. Yes, texting a couple of words to a person that is menacing, harassing, or causes offence can see a person charged with a Commonwealth offence. By the way, the defendant and the complainant are known to each other. It's possible they're family members, but it's really hard to hear from the gallery because of the ceiling fans. There is also now an AVO in place to protect the complainant. The defendant is self-represented and has a very frank discussion with the magistrate and is in agreement that the text should not have been sent. They're given a good behaviour bond in the end. So that's it for Kurri for 2024. I think it's important that the community hear about the petty crimes of Kurri to assist in deterring the community from doing petty crimes. Kurri is a great town. It's not all about petty crimes here. You could do this exercise in any of the New South Wales towns because we have petty crime in all sorts of places in New South Wales. I choose Kurri because I live nearby and they're friendly here. You can hear from the gallery most of the time. And like other local courts, there's always a case where you learn something new about petty crimes in New South Wales. So we'll be back in 2025 to hear more about the real crimes of Kurri. Big question is, will the usual Kurri magistrate return? Word around the courthouse is there may be a change to the Cessnock court circuit, which Kurri is a part of. We'll see when court returns to Kurri in 2025.